Hi there, I'm Savannah Mexto with Manor Law Group, and I'm excited to welcome you to another webinar Wednesday with esteemed elder law and estate planning attorney, Robert Manor. Today's webinar is for anyone who may at any time purchase real estate. Whether you're a first-time home buyer, inheriting your parents' home, or maybe purchasing your 7th investment property, signing a real estate deed holds big implications for you and your future. Today, Bob will discuss what you need to know before you sign your name on that deed. Now, before I pass the mic, I'd like to cover a few housekeeping details. Now, first, even though Bob is an attorney, today's webinar will not give specific legal advice. If you do have a question about your unique situation, please contact us after the webinar. If you have a general question during today's presentation, we encourage you to use the question box. We will save time to review questions during the webinar, and if we don't get to your question, we will contact you after the presentation. Also note that today's presentation will be recorded, and the replay will be sent out tomorrow so you can share that with family, friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Manor Law Group have to say? First, note that we're a nationally recognized and respected elder law and estate planning firm. All 3 of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Manor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's honored in 2020 as both a super lawyer and leading lawyer by those peer review lawyer rating organizations. Bob is currently on the executive board of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. Lastly, my favorite reason, Manor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd love to welcome attorney Bob Manor.
Hi, folks. This is going to be just a quick and easy one here. I just wanted to clarify a few things. We've been getting a lot of questions about deeds lately, so I thought it'd be worthwhile to spend a few minutes on deeds and how important they are, that they're done right, that the wording of it is right, that we have the right type of deed, and just some misnomers about deeds and people's expectations. One of the things that we're constantly saying here about deeds is that people don't take them seriously enough. It's often 1 page or 2 pages, and it just doesn't look that complicated. And the reality is that deeds are often the thing that causes the most complication, because there's expectations about what a deed should say and what word goes where and what words we use. And if we don't do it exactly right, it can cause all kinds of havoc. So I just wanted to clarify a few things. Recently, I had done a presentation and talked about quitclaim deeds and kind of used that as shorthand. I want to clarify what I mean by quitclaim deeds, because I don't want to say that all quitclaim deeds are bad, but I'm going to give some examples of what I meant, and also be a little bit more specific about how, quitclaim deeds, as well as every type of deed, can be very useful. We just have to make it used right. Recently, I was speaking with some people in the real estate industry, and we were kind of using that as shorthand to talk about quitclaim deeds that are done incorrectly. It's just because we see it so often. That's why we just kind of referenced it as quitclaim deeds. But I want to clarify, quitclaim deeds can be a very helpful and useful tool, and just kind of go through those options there for us. So let's get right into it. There's multiple different types of deeds that we're going to have in different purposes, and this is going to be a state-specific thing. Just out of curiosity, a few minutes ago, I was looking around at different types of deeds in different states, and it's one of the reasons why, if you have property in another state, we're going to consult with an attorney, and we want to say fund your trust or something like that. We're going to consult with an attorney in that state, because every locality, every state's going to have its own practices, its own procedures, its own terminology, its own wording of the deed. And not only is it that every state's going to have its own specifics, but it's actually probably, I don't want to say it's illegal, but it's certainly frowned upon in very specific ways and very aggressive ways for an attorney in another state to try to draft a deed for another state. So for example, you come in, you own property in Florida, we've got a Florida attorney who will draft that deed for you. I've seen enough Florida deeds, I could probably draft it myself, but I won't, because number one is again, you want to make sure that you have the peculiarities of that state. But secondly, that would be considered practicing law without a license. Preparing a deed is considered practicing law. So if I prepared a deed for Florida and I'm only licensed in Michigan, then that's an issue. So really, if you have a property in a different state, we need to get an attorney in that state to draft the actual document, whether it seems like a simple document or not. So here's some examples of deeds in Michigan, and we're going to talk about this particular slide is going to be specific to Michigan. So we're frequently using quitclaim deeds, and so the very common things that we're going to be looking at is the difference between a quitclaim deed and a warranty deed. And then I wanted to throw out this fiduciary deed too. So let's go through those one by one and talk about what each of them mean and why we might use them in different circumstances. So the quitclaim deed is literally the way it was described to us in law school is you're deeding whatever you own. Okay, so when you say you're quitclaiming it to somebody, you're not even warranting, you're not even promising that you own it. So I wouldn't recommend that you do this. You could probably get in big trouble for it, but in legal theory, so let's just make sure we're talking legal theory and you don't actually go ahead and do this, but in legal theory, you could quitclaim the White House to somebody else because you're not claiming that you own the White House. You're not claiming that you have the rights to sign that deed. That's what a quitclaim deed does. It doesn't actually guarantee that you own it. It just says whatever I happen to own, I'm transferring to this other party. And if I happen to own nothing, then I'm transferring nothing to the other party. And so that's why it's one of those things that we can have its purpose, but it's not you wouldn't want to accept if you purchased property for value, you're buying a house on the open market, you definitely would not want to have where you're accepting it as a quitclaim deed because you're not even getting a guarantee that they own it. And even when you get a quitclaim deed, let's say you're buying it from relatives and you say, well, I'm okay having them do a quitclaim deed as opposed to one of the other types of deeds. However, I'd highly recommend that you still go through a title company and still get title work and still particularly get title insurance, because even if you know this is from your dad or something like that, or your parents, or you're transferring it to your kids, even if you know you own it, you just want to make sure that there's not going to be some surprise later on that it turns out that Consumers Power has an easement, or that the neighbor actually owns 20 feet into your property, or whatever the scenario is, or there's a right of way, or there's any number of other encumbrances that could come up on this. So we strongly recommend, even if you use that quitclaim deed process, to get title work. Now, some of you that are our clients heard me present recently where I said quitclaim deeds are, maybe I didn't say this exactly, but it certainly came across as saying that quitclaim deeds are bad. And often in many circumstances, they are bad. Now, they're just not bad across the board. What quitclaim deeds, we often use them in our office when we're putting a house into a trust or putting real estate into a trust. So you'll remember a trust is sort of a will alternative. So instead of going through a will and going through probate, we set up a trust, which is a contract between you and your family that says how you want things managed during your lifetime, how you want your assets managed if you get incapacitated, and how you want your assets managed and distributed after your death. And we can do it through a trust and have the assets in the trust so that you can stay out of probate, stay out of court, keep family matters in the family, have a good succession built in there, have a plan in case you get sick, all of these things, and then some of the advantages of trust. And so you'll notice that when we do a trust, we're often using these quitclaim deeds to put the house into the trust. So if you remember with the trust, we got to put the stuff in there. That's why I'll often talk about a trust being a wagon. So we got to take your bank account and put it in the wagon, meaning the trust is the wagon. We got to take your house and put it in the wagon. Well, how do we do that? Well, at the bank, we should go to the bank and say, hey, by the way, we have a trust. I want you to list the trust as the owner of this account now. With a house, we're going to have to do a new deed, and we use a quitclaim deed to do that. So why? Because some lawyers will go to the effort of actually doing a warranty deed to transfer the house from the house, from mom and dad, from the clients into the trust, which still means mom and dad own it. Still, the clients still own it. Okay, whether it's in your name alone or it's in the trust, if you created the trust, you still own it. The law treats it as if you own it. So why wouldn't we use a warranty deed saying I warrant mom and dad, George and Sally, we're going to call the clients George and Sally today. So George and Sally say, well, I know I own the property, so why don't I sign a warranty deed that says not only am I giving whatever I own to the trust and making sure it's managed so that it will avoid probate and all of that, where you manage it so you don't lose any control or anything like that. So why would I do a quitclaim deed where I'm not guaranteeing I own it instead of a warranty deed where I am guaranteeing I'm owning it? And the answer is this. In my view, for us to prepare a warranty deed, we have to have title work, okay? We have to have recent title work, not just title work from when you bought it 30 years ago. So that is, and this is a matter of preference a little bit among lawyers. There's some lawyers that don't require title work for a warranty deed, but the bottom line is, if you're gonna say that you warrant it and we're preparing that document, I think that there should be some title work that says, okay, we've looked at it and there's nothing that's come up in between the last 30 years that you've owned this property, or 2 years or 2 months or whatever, that has encumbered this property, and we declare you own it free and clear of all encumbrances, okay? And so that's why we don't do warranty deeds to put the house into the trust. We do quitclaim deeds to put the house into the trust. Whether we do a warranty deed or a quitclaim deed, you still own it. So you come in, you do a trust, you own a house. Afterwards, the trust owns the house, but you own it either way because you own the trust. There is no distinction between you owning it and the trust owning it as long as you're alive. Once you die, there's a distinction. That means the house doesn't have to go through probate. But when you're alive, having the house in the trust is just like you owning it. In fact, to the extent that it doesn't protect it from your creditors. So if you're a single person and you end up running up a bunch of bills and your house is in a trust, is that house in the trust protected from your creditors? And the answer is no. They could still file a lien on it, whether it's in your name or in the trust. The purpose of the trust is not to protect it from creditors. It is to make sure it's going to be managed properly in case you get sick, and also distributed properly upon your death without having to go through a bunch of court process and lawyers and all the rest of that, okay? So that's why we do the distinction between a quitclaim deed, where you're saying, I am transferring whatever I own, to a warranty deed where you're saying, I warrant or I promise that I own it and I'm transferring it. So if you say I promise I own it, it turns out that there's a right of way, well, you kind of didn't, it's not accurate. So that's why it's just easier to do a quitclaim deed under those circumstances. And it doesn't put you in any worse shape because you're saying, well, I own it before I did the quitclaim deed to the trust, and I own it after I did the quitclaim deed to the trust. Now, if it's between different parties, often I am going to be recommending that we consider a warranty deed. What if it's between mom and dad? I mean, that's not what I meant. What if it's between mom and dad and kids? Well, first of all, we really have to look at that to say, well, why are we doing it that way? Is there actually a better way? Is there better clarity? So a lot of times mom and dad will say, well, I just want to transfer, I just want to give my cabin up north to the kids. Don't. I say don't because there's so many complications of that. Once you sign that deed, you do not own that anymore. You may lose some tax advantages of it. You may lose, but the big thing is it's considered a gift. And if you end up going in a nursing home within 5 years after giving that gift, you could be penalized for transferring that to the kids, for signing that deed. So it's really, unless there's some really clear reason as to why, and my advice is that you get advice from us, you call us up, you get advice from us, we can walk through it and we can talk about the other options and alternative options, and maybe the trust can set it up so you're not going to get the penalty, but the kids can get security that they're going to receive the property. There's a variety of options, but the sort of old-fashioned way, the way people kind of used to do it, which would be mom and dad are getting older, they're going to transfer the property to the kids. Don't do that. Don't do that without legal advice. It's often causes more problems than good. We see this with farmers a lot, right? The farmers say, well, I want to make sure the farm doesn't go through probate. Okay, so they're going to add the kids' names to the property. No, that's going to cause all kinds of problems. It's going to cause problems with taxes, property taxes, it may cause problems with if you go into a nursing home, it's going to cause all kinds of problems, and you no longer own it. Mom and dad don't realize sometimes that they actually are losing control over it as soon as they sign that document. Whether it's quitclaim deed or a warranty deed, it's still transferring it. Quitclaim deed is just saying, I'm not guaranteeing that there's not, I'm just transferring whatever I own. Where a warranty deed says, I promise I own everything that is included in this deed. What about a fiduciary deed? Why did I put that one on there as an option? Well, I often will see people, mom and dad die, you're the trustee of the trust, and then people will say, okay, well, I'm the daughter, Susie, Susie, I'm going to transfer the property out. I see that mom and dad put it in the trust with a quitclaim deed, so I'm going to transfer it out to the kids through a quitclaim deed. Several problems. Number one is, what are we doing with the property afterwards? If we're selling it, don't transfer it out and then sell it. So we got 3 kids, and Susie says, well, what we're going to do is we're going to settle the estate. I'm going to transfer it out to the 3 kids, Susie, Roger, and Danny, and then Susie, Roger, and Danny are going to sell the property. Oh, that is such a big mess. Don't do that. Have the trust sell it and then just divide up the money. That's going to be so much easier. Please don't do that, number one. Number 2 is you should probably be getting legal counsel. You should probably getting some advice from us, and come on in. We'll make sure that that's all set up properly and you're not going to create liabilities for yourself. But the third thing is, it shouldn't be a quitclaim deed. Because if you're Susie, the trustee of the trust of your parents' trust, you don't own it. And so if you do a quitclaim deed, you're saying, I'm transferring whatever I own, but in fact, you don't own it. You are a fiduciary. You're standing in the shoes of. And so what it should be is a fiduciary deed, where you're saying, I don't own this, but I'm in charge of it, and I have the authority to transfer it. So I'm going to transfer it in the way that is appropriate. So even if you're selling a house out of a trust, we should use a fiduciary deed, not a warranty deed or a quitclaim deed. Now, a fiduciary deed can be, to make things more complicated, a fiduciary deed can be a warranty deed, or a fiduciary deed can be a quitclaim deed. But we wouldn't want to just call it a warranty deed or quitclaim deed. We want to make sure we have that language in there for a fiduciary, because you're not saying that you own it and you're transferring what you own. You're saying you're in charge of it, you have authority, and you're transferring it. I put a couple other questions here that I thought were interesting because I get these questions all the time and there's some confusion. And one of the things that is confusing about this is it's different from state to state. So some of you know I went to law school in a different state. And so the law school I went to was more of a national law school, so they didn't really teach the state-specific law. As a lot of law schools, they kind of focus on their state's law. In my law school, they didn't. They really just looked at it as a national program, and so they didn't really just teach the law of that state. So, but what's interesting is, in that state, when you had a mortgage on the property, you didn't have the deed. You didn't hold that piece of paper that was the deed. You didn't have it in your hands, okay? The mortgage company, the bank, would hold that deed until you paid it off, and then they would send you the deed. That's not the way it works in Michigan. So that's where I think people get a lot of confusion. And so even when they're in Michigan, they say, well, I don't have the deed because I have a mortgage. Well, yes, you do. In Michigan, what they do is they transfer the deed. You own the deed. You physically hold that, and you send it to the county, and the county has a record of it. You have the deed subject to a mortgage. In other states, they hold the deed until the mortgage is paid off. In Michigan, you get the deed, and then it's subject to a mortgage, and then you just get a mortgage payoff when the mortgage is paid off, a mortgage release. So that's really a kind of an interesting aspect of that, is that when property is transferred, the deed has to transfer. What about a deed if you're selling on land contract? Well, that's the opposite. So if you're selling on land contract, you don't get the deed until the land contract is paid off. And that can be problematic sometimes, because what if the person who's selling the property dies before you pay it off? Now, who are you going to get to sign the deed? Well, hopefully it was in a trust, or hopefully there's an executor of the estate or something like that. And the real answer, and we addressed this recently when we were talking to a realtor and a title company, the real answer is, if you're going to get a land contract, you're going to want to escrow that deed. So you actually sign the deed and somebody else holds it. The title company holds it. Somebody else holds it. So that the seller dies, or the seller is otherwise incapacitated or anything else, doesn't matter. As soon as you can prove that the property is paid off, the escrow company can release that deed, because you don't get the deed until the land contract is paid off. Okay. I'm going to go on to another slide in a second here. If your house is in an irrevocable trust, is it protected from lawsuits? Good question with regard to revocable versus irrevocable. And first of all, let's be careful, because if it's an irrevocable trust, just make sure that it really is an irrevocable trust. Those terms are used so not interchangeable, but they're so close to each other that a lot of people will come to me and say, oh, I have an irrevocable trust, and really what they have is a revocable trust. So if it's an irrevocable trust, the answer is, I'm going to give you the classic lawyer answer, it depends. It depends, because the irrevocable trust, what was the purpose of the irrevocable trust? Revocable trusts are used very frequently. That is the standard. Most people, are really interested in a revocable trust because they want to stay out of probate. They want to avoid having to have everything go through the will and have to go through probate. And there's lots of other advantages of the revocable trust. But if it's in an irrevocable trust, there's a specific reason why it's in an irrevocable trust. And we've got to look at the terms. Remember, a trust is just a contract. So we got to look at the terms of that contract, of that trust, to say whether it's protected from lawsuits. And there's plenty of situations where it would not be protected from lawsuits. I would say the majority of time, if it's actually an irrevocable trust, meaning you've given up most of the control of that asset, it has, there's lots of different types of irrevocable trust. Sometimes you haven't, the level of control you give up depends on the type of irrevocable trust. But in many, many, many cases of irrevocable trust, the property would be protected from lawsuits, but not all. Okay, so that's one of those ones where it's going to be case specific, fact specific. We'd have to look at the trust and say, yes, whatever's in here is protected from lawsuits. But I can't say that as a blanket statement that anything in an irrevocable trust would be protected from lawsuits. I'd have to look at the terms of the trust, the words in the trust, and we'd have to talk about why was the trust created in the first place. Okay. All right, so let's go on to the next slide here, and we can ask any follow-up questions too. Let's see. Okay, so I did some examples here. And so recently I had a presentation where I probably was a little bit too loose with my words, and we were kind of implying that quitclaim deeds were bad. Well, they're not bad per se. They're not bad on their face. It's just simply that people misuse them so often. And even this picture here, I don't like this picture because it's a fill in the blank form. Just don't do a fill in the blank quitclaim deed form. It's such a bad idea. We see these every single week. Once a week, we have a quitclaim deed come in that's going to cause all kinds of havoc and cause the clients all kinds of problems, and rarely actually accomplishes what the person thinks that, that signed it thinks that it accomplished. So I gave some examples here of good versus bad. So let's look at some of the examples of bad. From John Q. Sample to Jane and Jamie Smith. Okay, so there's several problems here. What was the intent of John Q. Sample? Well, I don't really know. I don't know who Jane and Jamie Smith are. I don't know if John has the authority and has the, really fully owns that property. But I do know that by just saying to Jane and Jamie Smith, that you're not telling us how Jane and Jamie Smith own it and how what the nature of their ownership is. So are Jane and Jamie, are they brother and sister? Are they married couple? Are they husband and wife? I don't know that. And we need to know that on the face of the deed. Why? Because that's going to determine how they own it. So if it says Jane and Jamie and Jane dies, who owns the property? Well, I'm going to tell you in a second who owns it and what what the issue is. But the problem is it's not clear on the face of the deed. So, for example, if it said to Jane and Jamie as tenants in common, then we would know that Jane owns 50% of it and Jamie owns 50% of it. And so if Jane dies, that means Jane's 50% is going to go to Jane's heirs, and it's going to go through probate. Okay, and Jamie is going to own the other 50%, and he doesn't automatically get Jane's share. Jane's share is going to go through Jane's estate. All right. What if it says joint tenants? Well, joint tenants, it says if Jane dies, then it all goes to Jamie. Well, is that what John Q. Sample had intended? You know, if John and Jane and Jamie are brother and sister, that's maybe not what John Q. Sample had intended. Maybe they had intended that Jane would be able to pass her share onto her family, onto her kids, onto her spouse, whatever. So why did I say that? In fact, if this was the language, and we see this language very frequently, why that if Jane dies, that her share would go through probate? And the answer is, if it's blank in Michigan, if you do not say how they own it or what the nature of their relationship is, then it is assumed that they own it by tenants in common, meaning they each own 50% of it. And if they each own 50% of it, when Jane dies, that means her share has to go through probate and go through her estate. Okay. So if you leave it blank, the presumption in Michigan is not presumption. Presumption is rebuttable. Okay. There's a difference between a presumption with lawyers. With lawyers, when we say presumption, that means it's presumed that, but in fact, you can prove otherwise. With a deed, you can't presume anything. It is the words that are on the page. You can't use any outside evidence. And this will be clear in a second here, by saying you can't use any outside evidence. But what that means is that, in fact, it is owned by tenants in common. Not an assumption, not a presumption, but in fact, with this language, it's owned as tenants in common, meaning they each own 50% of it. What about this next one? From John Q. Sample to John Q. Sample and Roger Sample and Sharon Sample. I see this very frequently. And my guess is, not knowing because it doesn't tell us, but my guess is what that would mean is what was happening there is John is dad and Roger and Sharon are the kids. And John's trying to make sure he avoids probate. So John says, okay, from me to me and my kids, that way I still own it, but Roger and Sharon will get it when I die. Nope, that's not gonna happen at all. It's not what it did, didn't accomplish what you wanted to do. What it's gonna do is it's gonna say, okay, John dies thinking he's avoiding probate. Nope, 1/3 of the property because it's blank, then that means tenants in common. Because if you don't tell us, then the state says it's tenants in common. So that means John dies, John's 1/3 share of that farm goes through probate. And Roger and Sharon's share, they own their share. Also, what if Roger, so John says from John to Roger and Sharon, and Roger has a stroke. So dad's still alive, dad John is alive, and Roger goes and has a stroke, and now he needs 24-hour care, ends up in a nursing home. Well, guess what? You deeded it to Roger. 1/3 of it is Roger's now. You didn't say how you own it, and so now your farm is subject to Roger's, even though Roger never put a dime into it, maybe never plowed a field or picked green beans off of the farm or whatever it is that you're planting, and yet the farm is now subject to Roger's medical expenses. Okay. Another bad example, from John Q. Sample to John Q. Sample, Roger Sample and Sharon Sample as tenants in common with rights of survivorship. So you think, okay, well, that's a little bit better, right? That means rights of survivorship. I've heard that language. That must mean that it's going to go to whoever lives longest. So if John dies, his share doesn't go through probate. Nope, wrong again. And the reason is because tenants in common and rights of survivorship are contradictory terms. And I see this all the time. I'll see that language, tenants in common, rights of survivorship. They mean the opposite things. You can't have something that'd be like saying, I don't know, I'm not going to give an example. Basically, tenants in common and rights of survivorship are the exact opposite. So if you say it's tenants in common and then say rights of survivorship, it means there's a cloud on title because we don't have clarity. Basically, it's going to be interpreted as tenants in common because you said tenants in common. So you can delete the rights of survivorship part of it. It doesn't work just to put that language on there. Okay, so let's go through a couple of examples of good options here. So the good options, from John Q. Sample, a single man whose address is, let me put the address, to George and Sally Sample, husband and wife. Okay, now why is this good? Well, number one is we're transferring it this might be from dad to George and his spouse, or no, it'd be George and his spouse probably, but has those words husband and wife. And that, oddly enough, takes the place of every other thing. And so, meaning that we don't have to say tenants in common, we don't have to say rights of survivorship, we don't have to say any of that, because the words husband and wife, and we could probably use the term spouses, as George and Sally spouses, you know, that might be the more modern way of saying that, that implies in Michigan, or not implies, it means in Michigan, what's called tenants of the entirety. Tenants of the entirety is a special property right only for married couples. And so you got to have that language that says spouses or husband and wife, or some indication that they're spouses. So this is an example of what I said earlier about when we look at a deed, we can't look at any outside evidence. So I had a deed I saw recently where somebody had signed a deed, from John Q. Sample to George and Sally, his wife. And then it was dated, let's say January 1st, 2000, the year 2000. And I said, and we, through the conversation, we said, okay, well, when did you get married? Oh, we got married in 2002. Okay. So now we've got a cloud on title again, because it says something that isn't true, because she was not his wife in January 1st of 2000. And so we got a problem there that creates a cloud on title. But the opposite, we can't bring in extraneous evidence. So if it just says to George and Sally Sample, but doesn't say husband and wife, if it was just like this one over here, just a second. If it was like this one over here that says to Jane and Jamie Smith, let's say now that they're husband and wife, because it doesn't say husband and wife, because it doesn't say spouses, they don't get that tenants of the entirety, even if in fact they were married. So even if we can say, well, no, but Judge, they were actually married, and it said to Jane and Jamie Smith, they were a married couple, doesn't matter, the deed doesn't say they were married. So in one case, when it said they were married when they weren't, the outside information makes the deed cause a problem with the deed. But in the other case where they were married, but it doesn't say they're married, then we don't get to bring in that outside information. So now they own it by tenants in the entirety, and they're going to end up in probate when one of the people passes away. All right. At this point, if your head is spinning a little bit, good. This is my point. Deeds are complicated. Deeds are actually really complicated, and you have to be very precise. We have the process in our office when we do deeds. You would be shocked and surprised by how many reviews the deed goes through. So people sign these deeds willy-nilly all over the place, and they get these blank forms and fill out these blank forms, and that yet in a lawyer's office, we have it reviewed by at least 2 different lawyers. It goes through a whole scrutiny process every single time before we file any deed. We scrutinize it because it's so easy to make a mistake on a deed. And so my point, if it seems like this is a lot of information, good. That's the point of this. You shouldn't be signing forms. You shouldn't be just making assumptions about it's okay to fill out this form because the registry deeds handed out, or the title company handed it out, or I got it from Office Depot, or whatever it is. This is just a bad idea. These are complicated concepts here. Okay. So the other one here, and this is the typical quitclaim deed that we use all the time, from John Q. Sample, a single man whose address is to the trustee of John Q. Sample Revocable Trust, dated June 1st, 2020, whose address is. Okay, so this is the typical format of the quitclaim deeds that we do in our office, which says that we're putting it into the trust. We're putting it in, if you hear me refer to the trust as a wagon, we're putting the house into the wagon. And that's the language that we use. That means John Q. Sample still owns it. He still has the full and complete rights to it. But when he dies, somebody else has the authority over it, and we're not going to have to go through probate, and we can manage it during incapacity and all the other benefits that we get from a trust. All right, so I did want to touch on this. I did touch on this recently in one of the recent presentations. I just want to make sure everybody's on the same page on this. When you go to sell a house from a trust, the title company often is going to want a new document. called a certificate of trust. Think of the certificate of trust as a summary of the trust. A summary of the trust that says, trust exists, has not been revoked, and here's who's in charge. That's basically what the certificate of trust says. Often it's a page or two. We usually do about a 2-page certificate of trust. It's not like the 80-page whole trust document. So 2 pages, we file that with the county register of deeds. Most title companies, most real estate companies are going to want one that's dated within a short period of time before the sale of the property, before the closing of the property. So what happens is people get this trust, we put the house in the trust, 10 years later they go to sell their house and they're surprised that they're going to have a new legal document that has to be created. And often they'll say, well, why didn't you just create that document 10 years ago? Because you knew someday I'd sell this house. And the answer is because it wouldn't have done any good. Title company, the real estate company, the buyers are all going to want something dated recently that says trust exists, hasn't been revoked, here's who's in charge, okay? There's of course a legal fee associated with that. It is something the title company could prepare. Almost always the title company is going to ask us to prepare it, and there's going to be a small fee for it. It's a pretty small fee, but the bottom line is it's because it's not something that we could do in advance. It is additional legal work, and although the title company could do it, they're just going to pay a different lawyer to do it, and they're probably going to charge you more than we would. So you can have the title company do it, but I think the reason why the title companies usually come to us and say, you know, you prepare it, and then we'll just include that in the closing costs, is because it's probably going to be cheaper for the attorney that drafted the trust to sign and create that new certificate of trust. All right. One other thing, what if you want to refinance your house and it's in a trust? This is just sort of an odd process, but the most mortgage companies are going to ask you to take the house out of the trust, so deed it out of the trust, sign the mortgage, and the very next day we're going to put it right back in the trust to refinance your house. So it's a little bit of a hassle. It's not our requirement, it's the mortgage company's requirement, and it's just one of those things that if you have a trust, expect that to happen if you're refinancing. I want to talk a little bit about real estate and property taxes. It's very important. There's 2 very important things that you're going to want to consider whenever you're transferring property. Is this transfer, when you sign a deed, is this transfer going to cause me to lose my personal residence exemption? Sometimes people call it the homestead exemption. So that personal residence exemption, if you're old enough, you may remember back in, I don't know, 20 years ago or 30 years ago, there was that Headley Amendment. Headley Amendment said that your property taxes couldn't go up more than a certain amount if it's your residence. Every year, it's capped. It can't go up over a certain amount for your personal residence exemption. You get a homestead at what percentage of it is homesteaded, all these things. Bottom line is when we're signing deeds, we want to make sure we're not going to lose our personal residence exemption if we have one, if there's any way to avoid that. And then the second thing is, can we make sure when property is transferred, regardless of the personal residency exemption, this is a separate thing, is whether or not it can be uncapped. In other words, can the assessor come out and reassess it at a different value and make you pay more taxes, reassess it? And the answer is that it depends on the deed. How the deed is written is going to be a lot on whether or not they can uncap it. Even when we're transferring from dad to kids, even when dad passes away, even when we're transferring out of a trust, how we put it in the trust, how we take it out of the trust, the wording of that deed is going to make a big difference as to whether the taxes are going to go through the roof or not. The wording of the deed is very important. And there's also this thing called a property transfer affidavit that gets filed with the deed, or at the same time as the deed, actually. And we have to make sure both of those are filled out exactly right. Otherwise, your property taxes could go through the roof. And again, that's what lawyers are for. That's what we're here for, is to make sure all this stuff is easy for you. I'm doing all these webinars to kind of clue you into what my world looks like. But remember, that's what I'm here for. You don't need to know all this stuff. You don't have to memorize all this stuff. You don't have to worry that you got all that straight, because that's what we're here for. You just call us. We'll make sure it's taken care of properly. All right, so let's see. Did I have, oops, let's go back. I thought there was one other issue, but I think that's it. So I answered the one question, Savannah, but is there any other questions that we have today?
No, Bob, we have no other questions. So if you do have a question, now's your last chance to go ahead and put that in the question box for us today.
All right, so I hope I answered the one question correct, or not correctly, but sufficiently. just to kind of recap, if your house is in an irrevocable trust, is it protected from lawsuits? Maybe. We'd have to look at the terms of the trust and the purpose of the irrevocable trust. And there's a good chance that it is, but we have to, I can't answer that question fully without reading the deed and reading the trust. Okay. So, all right, well, Savannah, I'm going to have you take it away and kind of give them instructions about how to get more information and how to learn more and maybe get a hold of us if they have some legal needs.
Absolutely. Thanks, Bob. And thanks for everyone for joining us today. Now, we do have an easy way for you to get in touch with our team. Of course, you can always call us. Our phone number, I'll put it in the chat right now, is 810-694-9000. We also have a way that you can select a day and time for our team to give you a call. And I'll go ahead and put that into the chat box as well. There is a link. You'll click the link. It will take you to a calendar. You'll choose a day and a time. And on that day and time, a member of our intake team will give you a call. Through that call, they'll ask you a few questions about your concerns, your situation, your goals, and then you can ask us questions. Think of it as a way for you to interview our firm to see if you really like what we do, if you like our team, and if you'd like to work with us. So I do encourage you to click that link and schedule the call. There's no cost. There's no obligation to move forward or sign up for anything. It's just a chance for you to get to know us. So again, I put that in the chat box, and then I'm also sending out an email that you should get any minute now. That same email will have the link for you there as well. Tomorrow, you'll get a replay of today's webinar. So if you have any questions between now and then, of course, reach out to us. We're here. Thanks again for joining, everyone. Have a great day, and we'll see you next week.